Go ahead and get started. Well, good morning. My name is Donna Kutzer, and I am the Development Director at the ARC of San Antonio. I would like to welcome you all to our webinar on Guardianship and Alternatives, which is brought to you by our sponsors, including the Gordon Hartman Family Foundation, New Star, the Greehey Family Foundation, Valero, Jefferson Bank, HEB, the Mays Family Foundation, and the Harvey Najum Foundation. Let me take a few moments, for some basic housekeeping. We are going to mute everyone's microphone and turn off the video just so it minimizes the distractions on this side. So we'll mute that. We'll be doing that as people enter. We'll do that at this time. We will leave time at the end of the presentation for questions. If you have questions, though, we ask that you key them into the chat box and we'll answer them at the end of the presentation today. We will, after the session, provide you with a link to the recording of the presentation and the presentations themselves for future reference and for sharing with others who may be interested in the information. It gives me great pleasure to introduce Heather Long, the Director of the Family Support Services Program here at the ARC. Family Support Services provides help to caregivers in navigating programs and services. So please welcome Heather, who will introduce our guests.
Thank you, Donna. I'm really excited for the presentation today. I think this topic is one that every family that I meet with ends up having a question about guardianship or alternatives. And so I'm so happy to have Julie Balovich with us. Julie is an attorney with the Texas RioGrande Legal Aid, and we had some fabulous opportunities to partner on alternative clinics, and we look to do those again in the future. And so I'm really happy that Julie could join us today. So I'm going to go ahead and turn this over to Julie so we can get started. And I know a lot of folks have questions. So as we're going, just make sure you put those questions in the chat box. And we did have some folks submit questions beforehand, and so I think that's really going to kind of help drive our presentation for today. So thank you, Julie.
Thank you, Heather, and thank you, Donna. I'm really pleased to be here. Texas RioGrande Legal Aid is a nonprofit law firm. We provide free legal services to people of low income in 68 counties, including Bexar County. For the last several years, we've been collaborating with the ARC of San Antonio, Disability Rights Texas, St. Mary's Law School, and the San Antonio Legal Services Association on guardianship alternative clinics. It's been a fantastic partnership, and I really appreciate the opportunity to speak to you today. This is one of my favorite presentations to give. I really love working with families in this area because I know that there are so many concerns and stresses that you have, and if there's a theme of this presentation, it's going to be okay. Don't worry, there's a lot of information, there's a lot of options, but don't freak out. So I am going to be talking about guardianship alternatives and guardianships, which if you are working with a person with special needs, you've been hearing about these topics for several years and you may have a lot of questions. I'm going to be talking about what the differences in guardianships. I'm going to be talking about different kinds of alternatives for guardianship, when they can be used, and I'm going to explain the process for both. What I'm not going to be able to do is give you legal advice about your specific situation. What I'm going to explain to you today is information it's legal information. It's available in a lot of forums. You can find a lot of the information I'm talking about on the internet. But the reason I can't give you legal advice is when you consult with an attorney, they need to have quite a bit of information about your specific situation to give you advice. And this is not the right forum for that. So please understand that the information I'm giving you is information that, for your benefit, but it is not legal advice about your specific situation. Okay, so why are we talking about this? As we all know, parents are the natural guardians of their children's persons until they turn 18. What does that mean? That means that if you are a parent, up until the time your child turned 18, if you were not involved in a divorce, a custody case, a CPS case, there was no court involvement in how you parented. Nobody questioned your ability to make decisions for your child. You had that right under Texas law as their parent. Or if you were appointed by a court, if you're a grandparent or an aunt or uncle, then you had those rights. But those rights end when your child turns 18. Why? Because as we know in Texas, when a child turns 18, they become an adult. And with adulthood comes rights of adulthood. They include the right to vote, the right to get a marriage license and get married, the right to contract, which can be signing a lease. And then most significantly for kids who are still in high school when they turn 18, they have the right to make educational decisions for themselves, and they have the right to consent to their own medical treatment. Now, this is stressful for any parent, of course, but if you are a parent of a child who has a developmental disability that began before they turned 18, this may be particularly stressful. You may be concerned that my adult child is still going to need help taking care of themselves because they have a mental or physical condition that impacts their ability to make these decisions. They're not going to be able to meet these needs on their own. So what does it mean that your adult child now has all of these rights? And that's why we start talking about guardianship, because that is the process that happens if a person becomes an adult and they still need somebody to take care of them. Historically, guardianship was really the only option for people with disabilities. People with disabilities were not recognized as having autonomy. They were sort of assumed to not be able to handle things. And so traditionally what you would see is people saying, well, you have to get guardianship. If you have a child who is in a special education program at school, by federal law, starting when your child turned 14, the school probably started talking to you about guardianship and transition. And more recently, they started talking to you about guardianship alternatives. The reason they did that, like I said, is there's a federal law that requires, it's called IDEA, that requires special education programs to start giving information to parents whose children are in these programs that when they turn 18, all of the rights of the parent are going to go to that child. So that is why you started getting this information. That is why you started hearing about guardianships and guardianship alternatives. What that does not mean is that you have to get a guardianship or that you have to do one of these things. It's just information that's provided to you. And so what I'm going to try to do in this presentation today is break down a lot of that information so you can kind of understand and see how it maybe applies to you. So why do we talk about alternatives to guardianship? First of all, alternatives to guardianship is sort of an overall term, and it refers to legal and non-legal options to help a person who has a disability that impairs their ability to meet their needs. So some of these options require a lawyer, some of these options don't require a lawyer. And the reason that I'm going to talk about alternatives to guardianship first is under Texas law, you have to see if alternative to guardianship work for your family before seeking guardianship. So these are things that you need to consider and determine that they don't work before you try to get a guardianship over a person with a disability. And let me be clear, when I say a person with a disability, this is not applying to any person with a disability. It applies to a person with a disability that impairs their ability to meet their needs, and that's a different issue. What I mean by that is just because somebody has a diagnosis or just because somebody has a disability doesn't mean that they necessarily need a guardianship or an alternative to guardianship. We all know people with disabilities are on broad spectrums of what they're able to do. We're only concerned about people who cannot provide food, clothing, shelter, financial, take care of their financial needs or their medical needs without help. So what are alternatives to guardianship? When I have a family member consult me about guardianship, the first question that I ask is, how is that person incapacitated? And like I mentioned, it's not about a diagnosis, it's about their actual functioning. What are the things that they are not able to do because of their physical or mental condition? Are they not able to speak? Are they not able to sign a contract? Are they not able to understand information that is given to them? I'm looking at their actual abilities and the things that they actually need help with. The second thing I look at is, are there any ways that those needs can be met without a legal guardianship? And that's how we explore alternatives to guardianship. There's basically 5 kind of areas of alternatives to guardianship that I'm going to talk about and that you may have heard about. One is supports and services. The other is person-centered planning, supported decision-making, surrogate decision-making, and powers of attorney. These alternatives are not standalone alternatives. You may have a support and service that works for your family, and you may rely on a type of surrogate decision-making, and you may rely on a power of attorney. These are all things that can be used alone or in conjunction to help meet the needs of a person who has a disability. And if these alternatives work, if they allow the person to have food, clothing, shelter, medical care, and have their financial needs met, then a guardianship is probably not necessary. Supports and services. This is a term that's actually in the law as supports and services, and so people think, what does this mean? And it means exactly what it sounds like. It's just the basic things that we do to help support people in our lives and to provide services to people in their lives. So supports and services can be very informal. Sometimes I will have people consult with me about guardianship, and when I ask them, how is your family member incapacitated? They will say, well, they have this disability and they're not able to cook for themselves, and they're not able to feed themselves, and they're not able to bathe themselves, and that is their disability. Well, if you are a family member and you have somebody in your life who can't feed themselves, cook for themselves, bathe for themselves, and those are things that you can do, those are things that you did for them before they turned 18, you can still do those things after they turn 18 without any kind of legal authority. Those are things, as long as they're not objecting and saying, don't touch me or don't help me, you can continue to provide that kind of care to anybody in your life without any kind of legal documents. It just requires you being able and willing to do that. So just if you're concerned about practical ways that your family member is not able to meet their needs in your home, and the plan is for them to continue to live in your home, then supports and services may work to resolve the issue. And that is an example of an alternative to guardianship. Supports and services can also be a little more formal. So for example, some people may have someone in their life who have those kinds of needs, but either because the family member has their own other children, or they have to work, or they have, the person's needs are above their level of taking care of them, or maybe they just don't want to, and that's totally valid as well. Then there are other kinds of programs that can provide those same kinds of services. Some of you may have heard of Medicaid waiver programs. Medicaid waiver programs are a way for Medicaid to pay for somebody to get services in the community, either living in their own home, living in a group home, living in a foster home, but not basically being in an institution. And those kinds of services can provide things like somebody to help with cooking, somebody to provide a place to live, somebody to provide transportation. You can get provider services that are either paid for by Medicaid or insurance, or just paid out of pocket. There are day programs that can provide activities and therapy and stimulation, and things that somebody can do if they're not able to work. Transportation aids in San Antonio. I know many of you are familiar with VIA, which is a service that can be obtained if somebody has a doctor's letter. And then there's assisted technology. So some people use iPads to communicate, or some people use computer programs to communicate, or Relay for people who are hearing impaired. So these are supports and services that are beyond just the services that you would just provide out of, the goodness of your heart in your home. The one thing I will say about some of these supports and services is they may require somebody to apply for them. And so if the person with the disability does not have the ability to sign an application, then you may need to look for another alternative for that portion of it. But at a minimum, these are programs that can provide a lot of the help with just the basics that a person with a disability needs. Person-centered planning. Again, this is kind of a technical term that appears in the law, but it's also just very natural and intuitive. It's stuff that all of us do in general, and then especially for people who have disabilities, who have special needs. So one reason people sometimes consult me for guardianship is they say, well, I can provide for my family member. I've been providing for them their whole life. I plan to provide for them, but I want a guardianship because what will happen if I'm gone? Well, that is for anybody, right? That can happen to anybody, whether they have a disability or not. And so it's always a good idea to have a plan in place about what will happen if you are a primary caregiver, who's going to step in that situation and provide the same services that you provide. And that doesn't necessarily require a guardianship. If you have a family unit that is fairly isolated, you don't have extended family, you don't have trusted friends, and you're concerned, like, I am the one person in my child's life, there's nobody else, this is a good time for you to think about getting connected with some kinds of services. So, and when I talk about services, I mean case management services. Center for Health Services is the local mental health authority. They're also the local Center for Intellectual Disability Services, and they have case management. There's programs like ARC of San Antonio. There's also the Agency for Area Disability and Resource Center. It's a really good idea if you have an isolated family unit where you're the only person in the person with a disability's life, to be connected to outside services, just as an alternate plan, so that somebody else kind of knows what your situation is and can step in if you're not there to take care of the person. I've sometimes heard from families of adults with disabilities who have behavioral issues that are related to their disabilities, that they want guardianship because they're concerned that somebody in the outside, law enforcement, or maybe an area of business, will react inappropriately if their family member expresses behaviors that are not criminal behaviors, but that are linked to their disability, that could be misunderstood. And whether you have a guardianship or not, it is a good idea to have relationships with people who know about your family member's disability and understand what it's about. So for example, I have a friend whose son has autism, and anytime she goes to a restaurant, she calls ahead to make sure there's not going to be music playing. If she goes to an airport, she makes sure that the terminal they're going to be in isn't going to have those loud noises. There's a lot of extra planning that she does. None of that requires guardianship, but to ensure that her son is not going to have, is not going to be in a situation where he's going to express behaviors that are not beyond his control, or that people will understand in advance. And again, that doesn't require any kind of specific legal action. Keeping lists of medications that work and do not work. A lot of kids go through lots of different medications before they figure out what works, and even into adulthood. And if you are the primary caregiver for your son or daughter, you may be the sole repository of that information. They may have gone through different doctors, different hospitals, and that's a really important way for you to provide some planning, some person-centered planning, if they are in a situation where they get admitted to a psychiatric hospital or somewhere where they don't have the background information on your son or daughter. And then finally, if your son or daughter is still in high school, there is the IEP plan, which you go over every time you have an ARD meeting. And you can incorporate into that IEP plan this kind of planning for what will happen when your son or daughter becomes an adult. You can start thinking about things with the professionals who work with your son or daughter. So that's person-centered planning. So now let's talk about supported decision-making. If you've never heard of supported decision-making, it's because under Texas law, it's relatively new. It was only on the books since 2015. But supported decision-making is something that we should all recognize happens in our lives, whether you have a disability or not. Supported decision-making under the law is the process by which people who have disabilities receive support from a trusted person. And that helps them kind of navigate all the situations that they're going to go into as an adult. But like I said, every one of us has supported decision-making in their life. If you think back to when I said a person turns 18 and they get all of the rights of an adult, very few people reach adulthood with all of the resources intact to just tackle adulthood. They still continue to receive support from their family members. To this day, I have no idea how my car works. And if I go see a mechanic and they give me a recommendation of something that I need to have done to my car, I am really not able to make that decision without consulting with my husband, who has decent mechanical knowledge and has the same in that I do in making sure my car works. He helps explain things so that I can make a decision. And so if you think about it, whether it's medical decisions in your life, whether it's advice about a relationship or cooking or finances, we all have supported decision-making. So under the law, supported decision-making is actually a legal document. And what it does is it allows the person who is the supporter the ability to do three things for the person who has the disability. They can help access information. They can help the person understand the information so they can make a decision, and they can help communicate the information. And the supported decision-making agreement is very simple. I'm actually going to put up on your screen what the supported decision-making agreement looks like. So this is the beginning of it. And it says, I, name of the person with the disability, am entering into this agreement voluntarily. That's very important. The person with the disability has to be willing and wanting to do this document. They can't be forced into doing it. They choose their supporter, and they can have more than one supporter. They can have a supported decision-making agreement with as many people as they want for as many different issues as they want. And they list the supporter's address, phone number, and email address if they have one. And then the document different kinds of decisions. What does the person need help with? Do they need help understanding medical decisions? Do they need help understanding mental health decisions? Do they need help managing money? They can check off any of these or none of these as they wish, and they can list something in other. So for example, I once had a client whose adult child had a child of her own. And the adult child really did not understand how to take care of their child or needed help with taking care of their child. So we put together a supported decision-making agreement that said the person with the disability chose their mother to help them with parenting decisions. And that helped the grandma when she went to the doctor's office to show that she was getting information, helping the parent with decision-making, and helping to communicate those decisions with the doctor. What's really important about a supported decision-making agreement is that the supporter does not make decisions for the person with the disability. This is something that you use to help the person with the disability understand their options. If their disability impairs their ability to communicate with other people, then it allows the supporter to help them get the information they need to make medical decisions. So if you remember, when I talked about when you turn 18, you have the right to consent to medical treatment for yourself. That also means you have the right to have your medical records be private. But if you need help making medical decisions, then you need your supporter, most likely, to be able to communicate with your doctor and to be able to get medical records. And so as part of this agreement, you can sign, the person with the disability can sign a HIPAA release, or they can put in their supported decision-making agreement, my supporter specifically has permission to communicate with the doctor to get information that they need. So that's something that can be really useful if you're at a doctor's office and they're saying, wait, your son or daughter is 18, I can't give you any information. If your son or daughter wants you to be there, if they want you to be able to help them understand their medical decisions, then this is a document that can make sure that the doctor knows you have permission to have access to this medical information. The agreement is then signed by the person with the disability and the supporter, and they have to sign it in front of 2 witnesses. So the witnesses need to be there when they're signing it, or they can be signed before a notary. In this time of COVID, when we are all in our quarantine bubbles, what I normally recommend is that if you're going to enter into this agreement, that you use people that you're already around, so you're not exposing yourself to new people. Or for folks who need a notary, a lot of times doctors' offices have notaries, banks have notaries, and they might be willing to notarize a document through a drive-through. But I recommend that if you're going to do this agreement and get the witnesses, that you do so in a safe way. The agreement is valid until it expires or until it is revoked. And as you remember, I said this is a voluntary agreement. That means that the person with the disability can tear it up at any time. They can also put in a natural expiration. So I once had a client who was 18 years old and really wanted the help of their parent, but didn't want it to continue forever. They wanted to put an expiration in it. And so we did a supported decision-making agreement that had an expiration in 1 year. Well, what happens after that year? The person with the disability can enter another agreement if they want to. They can continue. There's nothing about this SDMA that it's over, it can never be done again. But that gave the person with the disability some empowerment of knowing I'm in control of this document and I'm the one that decides if it continues. But your family may be different. Most of the time when I have done SDMAs, the person with the disability has wanted it to sort of continue on an ongoing basis, and that's fine. And again, that doesn't mean it will last forever. It can always be canceled at any point. So that's the supported decision-making agreement. And I'm going to have some resources at the end that shows you how to find these documents on your own. So now surrogate decision-making. So surrogate decision-making is a way that the law allows a person to make decisions for another person without that person's opinion, without being appointed by a court. So surrogate decision-making is appropriate when a person is incapacitated medically or financially, and I'm going to talk about the different laws that apply, and they can't choose somebody to help them with decisions. They're not going to be able to sign a supported decision-making agreement, perhaps. Or maybe they will, but they still need someone to make decisions for them. There are certain areas that the law permits this. So you might consider whether any of these apply to your case. So there's 3 ways that the law allows somebody to make medical decisions for another person without that person's express permission. There's a law called the Consent to Medical Treatment Act. This is under the Health and Safety Code. This applies when a person is incapacitated and unable to communicate, and they're in a hospital, a nursing home, or they're a consumer of a home and community-based service agency. So that's a lot of our group homes. If it is a HCS agency, then the law allows the next of kin to make medical decisions for them. And there's a priority of who the next of kin are. The first choice is a spouse. The second choice would be an adult parent, then adult children, and it kind of goes down the list. So if you think about it, this is kind of common sense, right? Because a lot of people don't have medical powers of attorney. They don't have guardians. But if I left my office and I got in my car and I was in a coma and I don't have those documents, they're not going to say, oh, we can't treat you, you're in a coma and you haven't signed documents. That's when this law comes into effect. It says, okay, under the law, Julie's spouse gets to make medical decisions for her. A lot of people go into nursing homes without guardianships or without powers of attorney. And the law doesn't say, oh, they're too bad, no one can make medical decisions for them. It permits surrogate decision making. And then it also permits, and this is probably most useful for family members of young adults who are in HCS agencies. The law permits medical treatment decisions if the person with the disability can't make them for themselves. So that is one option. Another option, again, is the Emergency Consent to Medical Treatment Act. This is not really surrogate decision making. This is if I am driving down the road and I'm in a car accident and a first responder shows up, they are allowed to provide life-sustaining treatment without anybody giving them the right to consent. So that kind of, in general, exists for everybody. Finally, if you have a family member in an intermediate care facility for people with intellectual disabilities, there is a surrogate decision-making process where the law permits basically the closest family members to come together and kind of form a team for who can help make decisions for them. So basically, if you have a family member in an HCS home or getting HCS care in a day and a half, this might be an option for medical decisions, if that's your number one concern. I also mentioned surrogate decision-making for finances, and the one that should be most familiar to you if you have a loved one who receives Social Security disability is the Representative Payee Program. The Representative Payee Program is one by which Social Security determines if a person who's getting Social Security benefits is not able to manage those benefits. They will choose a surrogate, and it's most typically the person who was the representative payee before they turned 18. That person will continue to manage their benefits and make sure that their shelter is paid for, that they're getting food, that they're getting clothing, and that person is accountable to Social Security. Now, a lot of folks come to me and say, but Social Security said I have to be the guardian. Nobody can tell you you have to be the guardian, and definitely Social Security cannot tell you you have to be the guardian. What most likely happened is Social Security asked you if you are the guardian, because if you are the guardian, then that's the first choice for who they're going to appoint as representative payee. But if the person does not have a legal guardian and they really can't take care of their finances for whatever reason, either because of a cognitive disability, because of mental illness, but something that means they're not going to be able to make sure their basic bills are paid, the Representative Payee Program is an absolute option. You simply need to contact Social Security about it. If that is your only concern about finances, you almost certainly do not require a guardianship. In addition, if there's other kinds of monies that come to a person who has a disability, who cannot manage their finances, there can be some options under the law for trusts. One thing I will say in general for life insurance policies, when people name as beneficiaries somebody who can't manage their finances because they are a minor child, then they may want to consider setting up a trustee. So these are options for finances that don't require a guardianship. Okay, so I've talked about supports and services, I've talked about person-centered planning, I've talked about some surrogate decision-making, and now I'm going to talk about powers of attorney. Powers of attorney are a way that a person can choose somebody else to make decisions for them. So the biggest difference between supported decision-making and a power of attorney is with a supported decision-making agreement, I, the person with the disability, make the decisions, you get to help me. With a power of attorney, I, the person with the disability, choose you to take action for me. So that's the big difference there. There's three kinds of powers of attorney that I'm going to talk about. The first one is a medical power of attorney. Now, a medical power of attorney does not allow a person with a disability to choose somebody to make decisions for them right now. Why? Because a medical power of attorney only comes into effect if a person is incapacitated. If a doctor has said they do not understand the decisions that I'm explaining to them, they cannot give informed consent. So a medical power of attorney is one that if it's signed, it's asleep. And it only wakes up if the person with a disability, or anyone can sign these, becomes incapacitated. So a medical power of attorney is a just-in-case document that really everybody should have, whether they have a disability or not. But a lot of times for folks, it makes them feel better to have their loved one make a medical power of attorney. So it's clear who they've chosen to make medical decisions if they're in a situation where they can't make them for themselves. So a good example would be somebody who perhaps suffers from seizures. So it's sort of an episodic incapacity. They're not incapacitated all the time, but if they're in a seizure situation, They can't make medical decisions for themselves, and so that would be a time that the medical power of attorney would wake up. A durable power of attorney is a document that happens right now, and a durable power of attorney can delegate really any authority that the person wants to give. Most common in the cases that I see is somebody wants to give somebody authority to deal with their public benefits, to deal with their bank, or to help them with, to handle educational decisions. So for example, some young adults I work with, they go to ARD meetings, they really don't want to deal with this, they're kids, they just want to live their kid life, and they don't want to make educational decisions, and they can sign a power of attorney that says, Mom, you handle the ARD meetings, I don't want to go, you make the choices for me. Or, Mom, I don't want to talk to Medicaid, I don't want to talk to AmeriGroup, when they call, you deal with that for me. That is when a durable power of attorney can be very, very effective. The person has to understand what they're signing, okay? So it's important that they understand what kind of decision-making authority that they give. And the person who's making decisions can only make decisions that they know that the person would want. So for example, if you have an 18-year-old and your 18-year-old is like, I'm graduating this year, I am not staying in school until I'm 21 or 22, but Mom, you keep going to the ARD meetings. You can't go to the ARD meeting and sign them up for school beyond what they want. They didn't give you that authority, okay? It's only if they you have to act for what they want. But that can be effective. Like I said, if people really have a trusted relationship and they know this person is going to make the right decisions and I trust whatever they do and they're going to do, I'm going to be in agreement with it, this can be a very convenient document to have. And then finally, an authorized representative is a form of power of attorney that's really only for health and human services. So if your son or daughter is getting SNAP or Medicaid, you have to submit renewal forms. You have to be able to communicate with the Medicare care organization. And this is a very simple form someone can sign saying, Mom is my authorized rep, Dad is my authorized rep. You communicate with my insurance for me. And I'm going to show you where to find this form on the internet. It's real simple. Okay. So I have talked about a lot of guardianship alternatives. I've talked about supports and services, person-centered planning, supported decision-making, surrogate decision-making, and powers of attorney. There's so much out there. How do you choose? Remember what I said in the beginning. Think about the areas where the person with a disability needs help. Do any of these options allow us to meet their needs? Do more than one of these options allow us to meet their needs? And if yes, we can put these together. And these are guardianship alternatives that will allow us to continue to help this person with a disability live successfully as an adult. So again, just real summary, finances, I talked about the rep payee. There's also a joint bank account, which sometimes people use. You could have a trust, which usually will require a lawyer, support a decision-making agreement, or a power of attorney. For medical decisions, it could be a supported decision-making agreement. It could be the Consent to Medical Treatment Act. It could be emergency consent. It could just be a HIPAA release or a medical power of attorney just in case. And then finally, for insurance needs, a durable power of attorney, a supported decision-making agreement, or an authorized rep will allow the person that the person with disability chooses to handle those things for them. Okay, so guardianships. We've tried alternatives to guardianship. None of them work. I still, my son or daughter cannot sign the forms to get the supports and services. My son or daughter does not understand a supported decision-making agreement. No matter, even the simplest form, they're not going to be able to make decisions. I've gone through these alternatives. I've really thought about them. Here is a way that their needs are not going to be met. So what if I have to choose guardianship? Guardianship is not bad. It's not a matter of last resort because it's bad. It's just that it is it's an area where the law comes into a person's life, a court comes into a person's life, and so we only do it as a matter of last resort. It is a court-created relationship. You don't walk into a lawyer's office and walk out without a guardianship. You're going to have to go to court to get it, and what happens is the court is going to have to terminate legally the person's rights to make decisions for themselves and give those rights to another person. And that sounds really harsh, but that may be necessary. The person may not have the capacity to make those decisions and they need somebody to do it for them. But what's really important is, again, is you have to go to court to get it. And then once you get it, you are under the supervision of the court. You don't walk out of court with your guardianship and then you go do whatever you want. You are going to have to be accountable to that court every single year of the guardianship of the person's life. Two things to know about guardianships: they are only an option if alternatives don't work, and they're always an option if alternatives don't work. In other words, don't worry, I want to do these alternatives, but maybe I really need a guardianship. Guardianship is always there if you absolutely need it, so don't worry about that. Basically, the guardianship process, you have to have an attorney. People have to be represented by a lawyer, and I'll talk a little bit more about that in a minute. You have to have a doctor certifying incapacity. Once the lawyer files the papers in court, the person with the disability is going to be notified, which is really weird, but think about it. If your rights were going to be taken away, you'd want to get notice too. So a sheriff is going to come and hand the documents to your son or daughter, and then all of the immediate family members are entitled to notice. There's going to be an attorney who represents the person who would be the proposed ward. Their job is to really make sure that their rights are not being taken away unless it needs to happen. So their job is to defend this guardianship. The person who's seeking guardianship is going to have to undergo a criminal background check and then a 1-hour training, and then they're going to go to court. And at court, they're going to swear under oath, I'm the person who wants to take care of my family member or my loved one. I have tried alternatives, or I've thought about alternatives. I've determined that they don't work, and I am ready to be the guardian under the supervision of the court. They will have to post a bond and then take an oath that I described. And then, like I said, when they walk out of the court with their letters of guardianship, to get those guardianship letters renewed, they have to file reports every single year and tell the judge, this is where my son or daughter's living. This is the medical care they received. This is how they're doing. Everything is fine. The court can send a visitor out to the home and check on them because, again, they are now under the supervision of the court. Why not guardianship just in case? This sounds like a really great way to protect a person. Again, the law says you have to try alternatives first, and this is a really permanent decision. I mean, technically, people's rights can be restored later, but that also requires hiring a lawyer. It can be very hard to undo. So that's why we don't do guardianship first. One thing I really want to emphasize is a lot of folks contact me when their son or daughter is 20 or much older and they're worried, I waited too late. I was told to start doing this before they turned 18. You know, I messed up. You did not mess up. It is better to start early to think about it, especially if you think you're going to need guardianships because those can cost money. It's good to think about it early because if you need a Medicaid waiver program, those have waiting lists. But do not worry that you've waited too late. If you have been able to meet your family members' needs up until this point, guardianship alternatives have worked. Up until now, you're okay. You can always apply for guardianship if you need it. You can always enter guardianship alternatives when you need them. So don't worry about that. For folks who know 100% we're definitely going to need guardianship, the earliest you can file is 6 months before the person's birthday. So people call me at 16. I know I need a guardianship. I want to get this process started. Start thinking about your options, start thinking about alternatives, but you cannot start the guardianship process until 6 months before their 18th birthday. Costs. Everyone asks me about costs. Okay, so I work for legal aid. We do not charge, but we have very limited resources. We can represent very few people. Guardianship alternatives are less expensive, but that's not why you choose them. You choose them because if they're going to work for your family, that's what the law requires. Most of them don't require an attorney. We do have clinics where we go through alternatives, and I'll explain how to apply for those. If you're going to get a guardianship, there are fees associated. There's filing fees. There's the cost of the lawyer to represent the applicant. There's the cost of the lawyer to represent the ward. There's a bond premium, which in Bexar County is about $130 a year. And there's the cost of annual reports. Now, there are ways for those things to be done at a reduced free fee. There is an agency called Catholic Charities that does guardianships on a sliding scale. If you qualify, if your family gets public benefits, you will almost certainly qualify for a waiver of the filing fees, which means you would not have to pay for the attorney to represent the ward or the filing fees or the annual report. So that can reduce the cost quite a bit. But if you are looking at having to hire a private attorney, anecdotally, I've heard that can be in the $3,000 range. That may be reduced if you qualify for the waivers, but I'm sensitive to the fact that's a lot of money. And so it is something to think about if you know you're going to need guardianship. So I'm going to provide this PowerPoint for anybody who wants it, but here are some referral agencies. TRLA and Disability Rights Texas can both provide guardianship alternatives. We will counsel you on them. And we can also give you referrals for guardianships. Like I said, Catholic Charities does both alternatives and guardianships at a sliding scale. And these are some places on the internet where you can find free resources, especially about guardianship alternatives. You can find a lot of the documents that I talked about, and I will make this available to anybody who has questions or who wants them. So finally, what I want you to take away from this is there are a lot of legal and non-legal options to meet the needs of a person with a disability. Nobody can tell you you have to get a guardianship. The only person who can decide there's a guardianship necessary is a judge. And remember, don't freak out. Guardianship's always an option if it's needed. You just have to consider alternatives first. So that is my presentation. I know I've probably have questions in the chat. Donna or Heather, are you able to access those?
Okay, can you hear me?
I can.
Donna, do you want to go ahead and ask the questions?
Yeah, I'm sorry, my camera, I don't know, won't come up. But one of the questions we are going to make, as Julie said, we're going to make this presentation available. So that was one of the questions. But if we do have a question, if someone is not able to sign their own name and are nonverbal, are the alternatives a possibility?
Great question. Yes, possibly. The question is going to be whether they understand, right? So being nonverbal is a type of disability. But if there's a person if there are other ways for them to communicate, so it can be shown that they have comprehension and they understand what they're signing, the law does not discriminate against a person who's not able to sign their own name. If they can make a mark and indicate that they are in agreement, then yes. But what it's going to come down to is, are they understanding what they were signing? I would never have somebody sign, and when I say sign, I don't mean just sign their name, but indicate agreement with something if I didn't feel clear that they understood that. And so in every situation, you're going to look at, are there ways to accommodate this disability?
I am not sure we had very many questions. I think by everyone submitting them ahead of time, we may have taken care of that. Does anyone, if you have a question, please be sure to type it in the chat now. We're going to give it a few seconds. If not, we'll wrap up this morning's session.
Because I started talking fast because I wanted to make sure I had time for questions.
Actually, we do have a couple coming in. Now we got some coming in. Okay. So does being a guardian affect the ward's eligibility for services?
It does not. It does not. So it may affect the ability of the guardian to provide those services. So there are some provider programs that do not allow the provider to also be a power of attorney or a guardian. So you'll need to look at the requirements of that specific program.
Okay, and then we also, if the person is not capable of understanding the consequences or implications of an alternative, then is guardianship the only real option?
So in every case, I look at what is the person's capacity and then what are the needs. So it's going to depend on both of those things. So if a person comes to me and they say, you know, they can't feed themselves and there's a way for them to be fed, that's a type of guardianship alternative. You're going to need to look at what is the incapacity and what is the need to determine whether alternatives will work. And remember, it's not all of these alternatives require somebody to sign something. Some of them do, some of them don't.
Okay, we have a question about guardianship. If guardianship is obtained, what happens when the guardian dies or becomes incapacitated? What
Great
is the
question.
risk of a special needs person becoming a ward of the state? What are their limits of supported decision making?
Okay, so technically, every time there is a guardianship, the ward is a ward of the state. What happens is the state becomes responsible for that person. It's just that somebody is chosen to be the guardian to make decisions for them. So if a guardian dies or becomes incapacitated, that ward is still a ward of the state. And it's the court's obligation to make sure that there's somebody now to make decisions for them. So that could be a successor guardian. It could be another family member who steps up, who does the criminal background check and the training. Or in some cases, it may be a public guardian if there is no family member or trusted person to take that role. But anytime a person is placed under guardianship, they are a ward of the state. It's just a matter of who the person actually making decisions. And that's why it's really important to understand, if you get a guardianship, don't just walk out the door and make all decisions for them and you're not accountable to anybody. You are accountable to that court.
Is there an age cutoff for any of the alternatives or for guardianship?
There is not an age cutoff when it ends. There is an age cutoff when it begins. Nothing can take effect until the person is 18, because before 18, it's mom or dad or whoever has been appointed by the court. After 18, some programs may have age requirements. So there's some kinds of like Star Plus. I think they're only for over 21. So you have to look at the requirements for the certain program. But when we're talking about things like powers of attorney, supported decision-making agreements, and just basic person-centered planning, any age as an adult will work.
Okay. My son can't write his name. My son can write his name, but he doesn't understand what he is signing. I don't know what to do as far as which alternative to use.
Sure. So you're going to look, anytime I analyze a guardianship case, I look at what is the person's abilities and then what are their needs. So what you're going to need to do to decide if a guardianship alternative will work is figure out what are the areas that your son or daughter needs help, and see whether there is an alternative that will work for it. And if there's not an alternative that will work, then you've considered guardianship alternatives, and you can go to the court and say, I've tried, and here is the specific need that cannot be met without the court appointing a legal guardian. And that's how I look at every single case. I can't give advice about your specific situation, but that is my general approach to all cases.
Okay. Will hand over hand signature be accepted when signing a POA?
So anytime a person has a disability, the law requires us to accommodate that disability. So if a person is not, let's say a person doesn't have hands at all, they can't sign their name. The law doesn't say, well, because you can't sign your name, you can't execute a power of attorney. So if there is any way to accommodate that person's disability in a way where the intent of the document is affected. So for example, if a notary is notarizing it, they can say, I notarized, I showed that assent was given by blank, and it could be somebody held their hand for them or whatever, but the notary is making sure that the person understood what they're signing. So whether it's hand over hand or whether it's somebody, getting somebody's agreement and signing for them, or whether it's through assisted technology, the fact of being able to physically unable to do something is not a reason to discriminate against them. People get real hung up on a signature requirement, and just remember that a signature is a way of you giving assent to something, saying, I understand and I agree to this document. So whatever way that can be accomplished to accommodate a person's disability is acceptable, as long as it's not involuntary, as long as they don't understand what they're doing. And that's going to be a case-by-case basis. So I don't know about a specific case.
Since a durable power of attorney does not cover medical, how do you legally make medical decisions?
You cannot make medical decisions for another person who has capacity using a medical power of attorney. A medical power of attorney is a sleeping document. So the person has to understand what they're signing, and they have to say, if I'm determined incapacitated by a doctor, this wakes up, and that's the person who can make medical decisions for me. So that is a limitation on a healthcare proxy. So for example, my husband cannot go to the doctor's office with a medical power of attorney and say, Julie consents to this medical treatment. I have a medical power of attorney. And me going, no, I don't want that. I have to make that decision. But if I go to the doctor and I cannot communicate and the doctor's like, Julie lacks capacity, that's when that medical power of attorney wakes up. For a person who has a disability, who's not necessarily incapacitated, but they need help understanding things, like, you know, somebody's talking to me about a medicine and I don't know what medicine they're talking about. And my supporter's like, remember, that's the medicine you took this time and you liked it and it worked really well for you. Oh, okay, I understand. I can sign that. But they need to have some comprehension of what's being communicated to them. So hopefully that helps. And then again, surrogate decision-making can only work if the person is an HCS patient, a home and community-based services program, or if they're in a nursing home, or if they're in a hospital, or if they're in an intermediate care facility.
Okay, I think we have one time for one more. This one is, how do guardianships transfer between states? Say the guardian moves or dies and the next guardian lives in a different state.
So that's a pretty specific question. It's going to depend on the state and it's going to depend on the need, but there is a transfer process if one is necessary. And you'll have to consult an attorney in either the origin or the transferring state to find out. But every state, Texas is different than other states. Every other state belongs to one law, and Texas is state transfer requirements. So that's something you'll need to consult an attorney about.
Awesome. Well, I want to thank Julie and Heather for their time this morning. I think this information was obviously super helpful. We have tons of questions. And I also want to acknowledge and thank Sarah Kazin, the Development and Communications Coordinator here at the ARC. She truly is the glue that holds our webinars together. So I want to thank Sarah. Later today, either today or probably tomorrow, you'll receive an email with a survey for feedback on this webinar. The survey also asks for ideas that you may have for future webinars. The email will also contain a link to the recording of the webinar on the ARC's YouTube channel, as well as where you can find the presentation. So you'll have information available, and you'll get this later today or later tomorrow. Again, I want to thank our sponsors for making the ARC's webinar series possible. Without them, we would not be able to do this. So we'd like to thank the Gordon Hartman Family Foundation, New Star, the Greehey Family Foundation, Valero, Jefferson Bank, HEB, the Mays Family Foundation, and the Harvey Najum Foundation. Please watch our Facebook for future webinars. And a friendly reminder, as you all know, the HEALS Act is being discussed in the Senate and the House today, and that is an extension of the stimulus package that was presented in light of COVID. Please feel free to reach out to your elected officials today, because because in instances they have not taken the needs of individuals with intellectual and developmental disabilities into consideration. So please feel free to dig in and reach out to your senators and help us make sure that our voices are heard and they know that we are essential. So thank you very much for joining us. Everyone have a wonderful day and stay safe and healthy. Thank you.
Thank you.